If you have almost no chance of winning your trial, and the defense now offers you $100,000 to settle, do you take the offer and call it a day? You want to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. As your case is getting closer and closer to trial, your attorney had a great medical expert who confirmed that you had a valid basis for a case. Now, as you get closer to trial, your attorney sends the doctor more updated medical records, more records about the deposition testimony that has taken place in your case, and now he's given him every single document that he needs in order to reevaluate your entire case. The one problem is, now the expert comes back to your attorney and says, hey, based upon this information, which I did not have before, the testimony from the various doctors and nurses, guess what? Now this expert has changed his mind and can no longer support your case. He says, there is no malpractice here. There is no wrongdoing. The injuries that you suffered are a known risk that can occur, and there is nothing here that the doctors did to cause and contribute to your injuries. Now, your case is getting close to trial. There have been no settlement discussions yet. The defense still believes that your attorney has a medical expert to support your case. And how do they know that? Because as your case gets closer to trial, your attorney is obligated to notify the defense of experts that he has retained in order to come in and testify at trial. And we are required to provide various information such as the doctor's credentials. We do not provide the name of the doctor. However, we provide all the credentials and the background and the schooling. So now when the defense does their own in-depth research, they will identify exactly who our expert is. But now, as you get closer, does the defense know that this expert no longer has the same opinion? Does the defense know that this expert has basically turned around and did a complete 180-degree turn and now says, sorry, I can't support your case anymore? The reality is no. They don't know this yet. Why? Because they haven't gotten to trial. Once you get to trial, now you are obligated, you, the injured patient's attorney. Now we are obligated to put on medical experts to support our claim, to show that we are slightly more likely right than wrong than what we are claiming is true. If we go forward with a trial, and now we put on all of our witnesses except for medical experts to support our case, and now we tell the judge, okay, judge, we have no more witnesses. We are done putting on all of our proof. You know what will happen? The first thing that's going to happen is the defense attorney is going to jump up out of his seat as if an ejection button was pressed and ask the judge to immediately throw your case out. Why? Because in New York, the law requires that we provide and produce a medical expert to testify on our behalf to support our case. If we don't produce a medical expert, you know what's going to happen? The judge is going to throw our case out. So you've got weeks prior to trial. The defense attorney calls your attorney and says, hey, listen, we're evaluating this case. We'd like to try and negotiate. We have an offer of $100,000. We don't have much flexibility. I might be able to get a little bit more, but that's it. Are you willing to take it? Will your client accept this? So now your attorney calls you and tells you that the defense just made an amazing offer of $100,000. He thinks he might be able to get a little bit more, maybe $110,000, maybe $120,000 to settle your case. And your attorney told the defense lawyer that he would have to talk to you to discuss this. And now you're thinking in the back of your mind, okay, you believe that your case is worth $1 million, $2 million, $5 million. Why? Because you believe that your injuries are significant. You believe that your injuries are permanent. And you know what? I'm sure they are. The problem is, in these medical malpractice cases, we have to show that the doctor was careless. And if we can't show that the doctor was careless with expert testimony, guess what? The jury will never get to consider the next question, which is, was the doctor's carelessness a cause of your injury? So if they never get to that next question, that means they will never get to the question about how much money you are to receive as a result of the doctor's carelessness. Because if he wasn't careless, then they never get to that point. And they're going to throw you out of court without a dime. Now your attorney explains to you, listen, we no longer have a medical expert. And you turn around and say, this is ridiculous, go get another expert. and you say you've already gotten 2 experts. There is no possible way a different expert is going to have a different opinion. And so now you are stuck between a rock and a hard place. Do you take what's behind door number 1, which is a guaranteed amount of money that the defense is now offering, the $100,000, maybe a little bit more? Or do you run the risk where you know for sure that if you go ahead and put on testimony, you go to trial, you testify, you get all these other witnesses to testify, except for the one key crucial witness that you need, the medical expert. If you don't produce a medical expert, your case is getting dismissed before the jury ever considers whether or not the doctor was careless. So do you have any options at this point? One of your options might be to try and find another medical expert to support your case. This will have to be done on an expedited emergency basis, and if the expert does in fact support your case and says, yes, you have a valid case, well, now your attorney has to notify the defense immediately that he's got another medical expert, and this has to be done in a timely fashion. If it's too close in time, it is quite possible that when your attorney goes to put that witness, that expert up on the witness stand, the defense is going to jump up out of his seat and yell out, "Objection, Judge, I object to Oginski calling this medical expert. We didn't have sufficient enough time to investigate this particular expert. We only got notified the night before trial." And you know what the judge is likely going to do in that instance? He's going to prevent this expert from testifying, preclude this witness, which means you don't have an expert to support your case. So you are in fact stuck between a rock and a hard place. What do? You have to make an educated decision together with your attorney to see whether or not accepting this offer is appropriate under the circumstances. And if it is, great, then your case is over and done. Or maybe the attorney goes back, tries to negotiate, obtain a little bit more money, and then your case is done and over. And then forever you will be wondering, why couldn't I get an expert? Why did they say I didn't have a case? And then you begin to realize, wait a second, this is really a gift. The defense didn't truly understand that we didn't have an expert to support our case. And in that instance, now what do? You go home and you thank God that the defense made this offer, otherwise you would have walked away with absolutely nothing. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand what can happen in these medical malpractice cases in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.